Good afternoon, everyone. Thank you for joining us on this Friday afternoon to delve into the interesting worlds of Texas civil procedure and family law cases. The State Bar has approved this webinar for 1 hour of CLE credit. My name is Dalia Castillo-Granados, and I am the director of a new project of the American Bar Association's Commission on Immigration, the Children's Immigration Law Academy, or CILA. We are an expert legal resource center created to enhance the quality of representation for immigrant children in Texas. CILA builds capacity for those seeking to advance the rights of immigrant children through training, technical assistance, and collaboration. We are a team of 4 and are located at the South Texas College of Law in Houston, Texas. If you have technical assistance requests, please call us, email us, or drop by our office. We are available for staff attorneys and pro bono attorneys on any issue related to children's immigration work. At CILA's April 1st day-long CLE at South Texas College of Law, we were fortunate to have 2 family law experts present on Family Law 101 and modification of foreign orders. If you missed the CLE, you can access those presentations through a webinar recording on Extra Legal if you work for a VERA legal service provider. If you're outside the VERA network, please send us an email and we will send you the recording of both presentations. In this presentation, I am building off of those 2 previous trainings that dealt with the substantive family law process. I'm going to discuss some of the same topics from the Family Law 101 and modification of foreign orders presentations, but focusing more on the procedural aspects of the requirements under the Family Code. If you have questions, please feel free to type them in via the chat function on your screen. I will do my best to address those questions during the course of the presentation, so there might be a slight pause between the slides, but I may need to answer others at the conclusion of the slides. What I want you to avoid when going into state court is this look on the judge's face. Personally, I love procedure, but I know for others this may not be the most exciting topic. It's important to know, however, and it will help you in court tremendously. Knowing the procedural rules will also help demystify a lot of the state court process. As my old clinic professor used to say, look at the rule and then come ask me your question, because he knew that a lot of questions would be answered if I did that. So why are a bunch of immigration attorneys interested in learning about state court procedural issues in the first place? To seek special immigrant juvenile status, of course, for clients that have suffered parental abuse, abandonment, or neglect. USCIS has made clear that template orders that recite the statutory language are usually not sufficient. The order should instead be clear as to the factual basis for each finding. What does that mean exactly? Here are some examples of the language that could be used in the order that would be helpful for USCIS to make a determination as to the applicant's eligibility for the status. For dependency or custody, the court finds that aunt is appointed sole managing conservator of the child. In other words, the court grants sole custody to the aunt. Since we use conservatorship instead of the term custody in Texas, the second sentence just makes this clear to USCIS. For parental reunification, based on the evidence presented, the court finds that the child cannot reunify with her mother because she abandoned the child in Honduras when she was 10 years old. The child's father is unknown. For best interest, it would not be in the child's best interest to return to Honduras where she has no family to care for her. The additional requirements of being unmarried and under 21 are not required in the order. These are the eligibility requirements for special migrant juvenile status outlined in the regulations, so USCIS can make that determination through the application process. In a civil litigation lawsuit in Texas, the parties must abide by the Texas Rules of Civil Procedure and the Texas Rules of Evidence. Local rules and procedures must also be followed. These can usually be located on the court's website, and I recommend you read through them before beginning any case in a new county. Additionally, on the substantive issue of the claim, the guiding principle will, of course, be the statute from which you're seeking relief. Here's an outline of what we will discuss about the civil litigation process in Texas. There are three main phases of civil litigation: pretrial, trial, and post-trial. Remember that this is all focused on cases where SIJS findings are sought, which will be either uncontested or default judgments. So we are not going to talk about everything that goes into a contested civil litigation lawsuit. In the pretrial phase, we will be focusing on filing, notice, and court appointments. One important bullet point that is missing here is the pretrial phase is discovery. But we are going to skip this topic because it will probably never come up in an SIJS case. At the trial phase, we will discuss some of the substantive rules on relief before moving into the rules of evidence that must be followed when presenting a case before the court. Finally, we'll discuss briefly what to do post-trial if you want to appeal a denial by the court of the relief requested. When going into state court, you have different options for the types of private suits to file. I excluded from this list dependency and delinquency suits that are brought by governmental agencies so that we can focus on the type of suits that individual attorneys can bring. In this presentation, we'll focus on an initial custody suit or suit affecting parent-child relationship. Other options under custody include modification suits, paternity and child support suits, and termination and adoption suits. Two other options are dependency and guardianship, which we will discuss briefly on the next two slides. If a child is in state foster care, then they are part of the dependency system. If a child is not in the state foster care system, a declaratory judgment is arguably one way to make a dependency finding in a private suit. The Declaratory Judgments Act comes from the Civil Practice and Remedies Code in Chapter 37. One argument that you may run into when presenting a declaratory judgment action is that it may not be considered a justiciable controversy if there is no opposing party in the suit. You could easily solve this by adding a defendant to the suit, but I know there may be circumstances where this is not feasible or practical. If the case is found to not be a justiciable controversy, then it could be deemed to be an advisory opinion, which is not allowed by the judicial branch. If you decide to move forward on a declaratory judgment petition, then you should have some arguments ready for why it is a justiciable controversy, even without opposing parties. I know there have been many questions in the past about whether a guardianship for a minor child can be used as a vehicle for getting the SIJS findings, but I haven't been able to find support for this for most SIJS cases in Texas. There are materials on the Texas Law Help website about kin care, the term used for when a child is being cared for by a non-parent family member, which recommends conservatorship and not guardianship if the non-parent wants to formalize the arrangement. For minor children under 18, the parent or surviving parent is automatically the guardian. Two ways SIJS findings could be made in a guardianship are for minor orphans or for an incapacitated adult. For a minor orphan, the nearest relative in direct line is entitled to guardianship. This would be a grandparent. In the case of more than one grandparent, then the court would only need to appoint one. Another way guardianship can be used is if a person over 18 is incapacitated in some way and needs a guardian. The court must first make a determination of incapacity, and a physician examination is required in this case. Now going back to an initial custody suit. A child custody determination, as defined under Section 152 of the Family Code, is a judgment, decree, or other court order that provides for legal custody, physical custody, or visitation of a child. This is the most common type of determination request made in state court for a child who is seeking special immigrant juvenile status. In order to hear this type of case, the court has to have jurisdiction to hear the matter and jurisdiction to make a determination in the case. An accompanying issue to jurisdiction is venue, or the rule that determines where an original SAPSR should be filed. Venue will typically be proper where the child resides unless another court has continuing exclusive jurisdiction. Continuing exclusive jurisdiction lies with the court that issued an earlier SAPSR order. This concept was adopted to curb forum shopping, races to the courthouse, child snatching, and multiple suits in different courts. Jurisdiction to hear different matters is laid out in the Texas Government Code. A Texas court has jurisdiction to hear a SAPSR suit only when it has been granted jurisdiction in family law matters. In Harris County, the family courts hear family law matters, while in Montgomery County, an outlying county of Houston and a much smaller county compared to Harris County, both general district courts and county courts hear family law matters. A Texas court has jurisdiction to hear a family law matter only when it has the authority to resolve the disputed issues in the suit. For child custody determinations, the court must have subject matter jurisdiction, or in rem jurisdiction, and for parentage or child support issues, the court must have personal jurisdiction, or in personam jurisdiction. The court can still resolve those issues for which it has jurisdiction without resolving all of the issues. But most courts are accustomed to seeing SAPSRs with both child custody and child support claims, which would require both subject matter jurisdiction and personal jurisdiction. If the case were contested, it would make sense for the court that has jurisdiction to resolve all of the pending issues to hear the case. But because most cases that require SIJS findings are uncontested, an attorney can make the argument that it is best to resolve the issue at hand, or custody, for the best interest of the child without having to make a determination about child support. To explain this a little bit more, let's compare a typical SAPSR case to a SAPSR case with SIJS findings. Here's an example of a typical SAPSR case. Mother and father never married and have 2 children together. Father signed an acknowledgement of paternity for both children in the hospital where they were born. The parents separate and mother files a suit for custody, visitation, and child support. The family has lived in Fort Bend County for the last 5 years. The mother would like to resolve all of the issues that can arise in a SAPSR. Venue is proper in Fort Bend County because all of the parties, including the children, live in the county. The court has both subject matter jurisdiction to hear the case and personal jurisdiction over all of the parties. The court can make a determination over all of the issues at hand. Now, let's look at a typical SAPSR case with SIJS findings. Mother arrives to the U.S. in 2005, leaving behind her daughter in El Salvador in the care of her mother. The father is listed on the birth certificate, but he has never provided any care or support for the child. The child's grandmother dies, and the child is forced to live with an abusive aunt until the mother decides to arrange for her trip to the United States. The father's current whereabouts are unknown. In this case, the mother brings a custody suit, and the court has subject matter jurisdiction to resolve that issue. It may not, however, have personal jurisdiction over the father, since he has probably never been in Texas and his whereabouts are unknown. The court would not be able to resolve the child support issue, but can still make a determination as to custody. Subject matter jurisdiction gives the court the power to adjudicate the status of a thing without needing personal jurisdiction over all of the parties. Child custody determinations are such a thing that can be adjudicated without needing personal jurisdiction. Child custody determinations must be made according to the Uniform Child Custody Jurisdiction and Enforcement Act, or UCCJEA. A court's in rem jurisdiction over a child's custody determination is established when one of the bases for jurisdiction under the UCCJEA is met. In order for a court to have subject matter jurisdiction to hear a child custody case, it must either have home state jurisdiction, significant connection jurisdiction, or default jurisdiction, in that order of priority. Home state jurisdiction is the most common basis for subject matter jurisdiction under the UCCJA. Home state means the state in which the child lived with a parent or person acting as a parent, which requires either legal custody or a claim to legal custody for at least 6 consecutive months prior to commencement of the suit. Each of the 3 requirements must be met. First, the child must have lived or been physically present in Texas. Second, the child must have lived with a parent or person acting as a parent. Third, the child must have lived in Texas for the statutory period of 6 months. If the child does not have a home state, then you move on to significant connection jurisdiction. This is met in either of 3 scenarios. If no other state was the child's home state during the 6 months before the child's custody suit began, the child and either the child's parent or parents or person acting as a parent has significant connection with Texas other than mere physical presence, and there is substantial evidence of care, protection, training, and personal relationships available in Texas, then you can meet the requirements. Significant connection jurisdiction can also be met if the child and parents are absent from the child's home state, there is significant connections with Texas, and substantial evidence of care is in Texas. And finally, you can meet this jurisdiction requirement if the child's home state has declined jurisdiction, there are significant connections with Texas, and there is substantial evidence of care in Texas. Finally, if there is no home state or significant connection jurisdiction, then you turn to default jurisdiction. This is met when all other states have declined jurisdiction or no other state has jurisdiction. If you cannot meet any of the above requirements for subject matter jurisdiction, you may still be able to argue for temporary emergency jurisdiction. As stated here, it applies only in extraordinary circumstances. To acquire temporary emergency jurisdiction, the child must be present in Texas and been the victim of abandonment, mistreatment, or abuse. The order under this jurisdictional provision will be temporary if another court has continuing exclusive jurisdiction and must specify a time period before it will expire. The emergency order can become final if there is no earlier custody determination that is entitled to enforcement, no child custody proceeding is commenced in another court, the emergency order states that it will become a final determination if no custody determination is commenced in another court, and Texas becomes the child's home state. Personal jurisdiction gives the court the power to impose a personal obligation on a party to the proceeding. This is what is required for the court to have authority to decide suits for child support and parentage. If the respondent is a resident of Texas, the personal jurisdiction is acquired with service of process, waiver of service, or when the respondent makes a general appearance. If the respondent is not a resident of Texas, which is the case in most of our SIJS cases, then the grounds for exercising personal jurisdiction are in Chapter 102 of the Family Code. There are 9 statutory grounds for the exercise of long-arm personal jurisdiction, and I've listed 3 here. The first and second presumptively satisfy the constitutional test for due process. The first, that the individual served in Texas, will likely not apply in SIJS cases. The second may if the respondent is willing to sign a waiver. The third, causing the child to live in Texas, may apply, but it depends on the facts of the case. It must be more than silent acquiescence to removal of the child to Texas. Additionally, for the statutory ground and others, it must meet the test for due process. This requires minimum contacts with the state, and it must comport with fair play and substantial justice. Standing was covered in the Family Law 101 presentation, but I wanted to bring it up again to point out some provisions that we may forget about when contemplating who has authority to bring a suit. A child has standing in a custody suit through a representative authorized by the court. This includes a guardian ad litem, attorney ad litem, or next friend. Next friend is defined under the Texas Rule of Civil Procedure 44. Through case law, we know that if a parent is available, then the parent assumes the role of a child's next friend. Another useful standing provision to remember is that a person who is a relative of the child within 3 degrees of consanguinity has standing if the parents are deceased, there is proof of significant impairment, or both parents have consented to the suit. And what is 3 degrees of consanguinity? It applies to siblings, nieces, nephews, aunts, uncles, grandparents, and great-grandparents. The contents of a petition are laid out in the Family Code. These are required unless marked optional. Under relief, there are a few other requirements which we will talk about in more detail in other slides. A UCCJEA affidavit is required as an attachment if not all the parties in the suit live in Texas. The information must be sworn to. It must include, if reasonably ascertainable, information about the child's current address and the places where the child has lived during the last 5 years, with the names and current addresses of the person the child has lived with during that period. It must contain information about any other proceeding concerning the custody of or visitation with the child. It must also state whether there are any other proceedings that could affect the current one. If a party alleges that the health, safety, or liberty of a party or the child would be jeopardized by the disclosure of required information, the information can be sealed. The civil case information sheet is also required under the Texas Rules of Civil Procedure. You can find the form and instructions for completing the form online. Here's the form, and you can see it is very easy to fill out. In section 1, you have the contact information for the person completing the form, which will usually be you as the attorney. In section 2, you indicate the case type. In section 3, the procedure or remedy. Section 4 will probably not apply since it's for damages. And you should submit this case information sheet at the same time that you're submitting your petition online. Now we're going to focus on service of process. As O'Connor's describes, this is a term that describes the formal process by which a plaintiff gives a defendant notice that he has been sued. The purpose of the citation is to give the court jurisdiction over the defendant, to satisfy due process requirements, and to give the defendant an opportunity to appear. The citation and a copy of the plaintiff's petition together are the process. The parties that must be served in the custody determination are under Family Code Section 102 and include the parent, an alleged father, and anyone with legal custody. Only a court clerk, officer, or person authorized by court order can serve process. No person who is a party to or interested in the outcome of a suit may serve process. I'm sorry, I skipped one slide, so we're going to go back a little bit and talk about filing fees. An affidavit of antecedent can be filed in lieu of the filing fees for any party who is unable to afford the cost. If you look at Texas Rule of Civil Procedure 145, you will find the required information under B, Contents of Affidavit, which include things like the amount of governmental entitlement income, employment income, and assets. If a party is represented by an attorney providing free legal services under an IOLTA program, an IOLTA certificate can be filed with the indigency affidavit, and it may not be contested. In order to be an IELTS program, then the program must receive IELTS funding. A defendant or clerk may contest an affidavit of indigence if it is not accompanied by an IELTS certificate. I didn't realize this, but as I was reviewing the rule, I noticed that an affidavit that attests to receipt of governmental entitlement may be contested only with respect to the truth of the statement. So if your client is receiving public benefits such as TANF or Medicaid for a USC child, then you can submit proof and the affidavit cannot be contested. If you cannot show this in your case, then you may face some aggressive tactics from the county attorney on the affidavit. All right, now moving on to service. We've already discussed who must be served and who may serve process. And we'll move on to methods of service. Process can be served on the defendant according to several different methods. Service by registered or certified mail, return receipt requested, is the most common method of service because it is cheap, easy, and can be tracked. These methods can be used for international mail as well, unless it is prohibited by foreign law or treaty. The difficult part for SIJS cases is getting a physical address where the post office can deliver the mail. A defendant can be served by personal delivery by any person authorized by law or court order, usually either an officer, such as a constable or sheriff, or a process server. There are international process servers, but they can be very expensive. If personal service or service by mail is attempted and unsuccessful, the court can authorize another method of service. A motion and affidavit must be made to the court describing the unsuccessful attempts at service and stating where the defendant can probably be found. Alternative methods of service could include another type of mail service or leaving service on the defendant's front door. Service by publication is a form of substituted service in which notice is published in a local newspaper. The rule was modified by the Family Code. Service by publication is not favored because it is seen as a poor substitute for actual service and should only be used as a last resort. Service by publication is generally found to be inadequate if the identity of the defendant is known, and that comes from case law. The petitioner and the attorney must make a diligent search before resorting to service by publication. Some things that can be done include contacting known relatives, interviewing neighbors or friends for last known whereabouts, mailing letters to the last known address, searching records, and checking social media services. There is a sample citation form in the Family Code which states that the deadline for answering the suit is by the first Monday after 20 days. The Texas Rules of Civil Procedure, however, provides that the deadline for the answer is after expiration of 42 days. This is something that remains unresolved. There is no case law that clarifies this issue, but I've been successful in the past with only waiting 20 days. This is how I understand the process from having done it in the past. It may work a little bit different in each county. First, you need to request citation by publication. Citation by publication is done through either Rule 106B, where personal service or service by mail was attempted but unsuccessful, or Rule 109, where the residence of the defendant is unknown. Under Rule 106B, a motion and affidavit for substituted service must be filed with the court, and the judge needs to grant an order allowing for substituted service. Under Rule 109, the rule only states that an attorney or party to the suit makes an oath and the clerk issues citation. So I understand this to mean that a motion to the court is not required. The next step is to complete the service of process form and pay the fees owed to the clerk. The clerk will then send the citation to the sheriff, who delivers it to the local newspaper of your choice. The newspaper will then contact you for payment. After receiving payment, the newspaper runs the citation once and then issues a publisher's affidavit to the clerk. Following the 20-day rule, if the respondent does not answer by the Monday after 20 days, then you can move the court for an appointment of an attorney ad litem for the absent party. There is case law that says that it is not up to the plaintiff to move for the appointment of the attorney, but this is the most practical way to get things moving. The attorney ad litem will then interview the parties and conduct their own diligent search before filing an answer with the court. After this, you are ready to move for a default judgment. A judge will decide if publication in a foreign newspaper is necessary. It might be best practice to use Rule 106B to avoid judicial critique of the method of publication later. Waiver of service is laid out in the Family Code under a new provision that was enacted during the 2015 legislative session. Under the new law, a court acquires personal jurisdiction over a non-resident respondent if the respondent waives service of process. In order to be valid, the waiver may not be signed using a digitized signature. I got nervous for a second that this meant a copy of a signature, since one of the easiest ways to get a waiver from Central America is by fax. But a digitized signature means something else entirely. It is a graphic image cut and pasted into various documents electronically. The mailing address of the party executing the waiver must also be included. Finally, the waiver must also be sworn before a notary public who is not an attorney in the suit. Section 132 of the Civil Practices and Remedies Code, which allows for unsworn declarations, cannot be used for a waiver under this provision. Finally, what happens if you need to make an amendment after the defendant has been served? If the amendment is to the petition, the defendant must be served again if the petition adds more claims or damages. But, for example, if there's an incorrect birth date of the child, you can amend it without having to serve again. For amendments to the citation or return, the court can authorize any process or proof of service to be amended, as long as there is no material prejudice that would result to the substantial rights of the defendant. For example, if the citation misspells the defendant's name, the court can, in its discretion, allow for an amendment without having to serve again. Finally, for the guidelines on service in foreign countries, see the Texas Rule of Civil Procedure at 108A. A person can be served by any method permitted in the rule. El Salvador and Guatemala are signatories to the Inter-American Convention on Letters Rogatory, but this treaty has not been deemed to be the exclusive or mandatory channel for transmission of service of process. Of the countries we most commonly see and accompany children from, Mexico is the only signatory to the Hague Service Convention. The Supreme Court has held that the Hague Service Convention preempts other forms of service and is mandatory for any country that is a signatory. It does not apply, however, if the respondent is unknown and is not implicated when the defendant voluntarily agrees to waive service. This is a little bit more substantive in nature, but related to service of process and something that we deal with often: who is the father? There are three types of fathers: presumed, acknowledged, and adjudicated. A father is presumed if he was married to the child's mother and the child was born during the marriage, or if he lived with the child for the first 2 years of the child's life. A father is acknowledged if he is listed as the father in a birth certificate. In the U.S., the father would have to sign an acknowledgement of paternity if he is not married to the mother. This is a form that must be executed by a certified entity. Usually, hospitals are a certified entity. I included here foreign birth certificate because 1, this is what I have argued in the past, and 2, each country has its own procedures for acknowledging paternity that are likely very similar to the U.S. provisions. If the country did not, then anyone could be named on the birth certificate, and there would be no stopping someone from naming Barack Obama as the father on the child's birth certificate. A father is adjudicated through admission when making an appearance, which can include a waiver of service, or through genetic testing. Let's discuss a frustrating and common situation in our SIJS cases. The father is not on the birth certificate, not married to the mother at the time of birth, did not live with the child for the first 2 years, and his whereabouts are currently unknown. What do you do? Here are some potential solutions. My first suggestion is to move forward on conservatorship with no adjudication of paternity. Since you don't have personal jurisdiction over this person, the judge will not make a paternity finding or order child support. The mother or non-parent can still request sole managing conservatorship. You can look at the voluntary abandonment provisions under Family Code Section 160 for some helpful language to make an abandonment finding. Now I know what you're thinking. What about the reunification finding for somebody who is not even adjudicated the father? I would argue that this is a fact-based determination that can be made with the testimony of the parties. If you or the judge don't like that argument, you can instead do a termination suit while seeking conservatorship. There are some helpful voluntary abandonment of alleged father provisions that are right on point. The final pretrial matter we'll discuss is court appointments. There are 3 types of appointments that the judge can make: attorney ad litem, amicus attorney, and guardian ad litem. An attorney ad litem provides legal services to the child, incapacitated person, or indigent parent. You will see this when serving a parent with citation by publication. An amicus attorney provides legal services directly to the court to protect the child's best interest. We have seen this recently in cases in Harris County. It is a discretionary appointment which you could contest. Finally, a guardian ad litem represents the child's best interest. On fees, if the appointment is discretionary when the judge is required, then the judge is required to take into account the party's ability to pay and balance that against the best interest of the child in making the appointment. If your client cannot pay the fee, you could contest either the appointment or the amount of the fee. Before moving on to the next phase, let's talk about a few instances where the case might end before trial. The plaintiff can voluntarily dismiss or non-suit the case at any time before all of the evidence is introduced. You'll need to file a motion in order to dismiss the suit. Plaintiffs have an absolute right to dismiss their own suit, but the judge still has to sign the order to get it off the docket. The court can also dismiss a case if the party fails to appear at a hearing or does not comply with the court's time standards. Most courts have scheduling orders, which you can ask for after filing the petition. If you do not move forward on a case, the case will be set on a DWAP docket, or dismissal for want of prosecution docket. You can always call the clerk before the DWAP date to ask for a continuance, or you can file a motion for continuance, or you can appear at the docket call to make your case before the judge on why the case has not been resolved and should get a continuance. You are also able to ask for reinstatement within 30 days if the case is dismissed. Now that we've gone over filing notice and court appointments in the pretrial phase, let's turn to the trial stage of the proceedings. The first thing you will want to do to prepare for trial is draft the judgment with all of the required contents and the appropriate findings. There's also some mandatory statutory language that you can find under this provision of the Family Code. Turning again to a more substantive issue, in a conservatorship, you must ask for conservatorship and possession and access, which is sometimes referred to as visitation. You can ask for child support if there is personal jurisdiction, but you do not have to request it in a conservatorship suit, although you do have to include medical support. More on that in a minute. Managing conservatorship is either sole or joint. There should also be a possessory conservator, or somebody who has possession and access rights or visitation. First, let's start with the parent who is seeking sole managing conservatorship. If there is no allegation of domestic violence, then the parent must overcome the joint managing conservatorship presumption. This is a rebuttable presumption that the best interest of the child is served with the joint managing conservatorship. If one parent is sole managing conservator, then the other parent must be possessory conservator unless the appointment would not be in the child's best interest, and allowing the other parent to have possession and access would endanger the child's physical and emotional welfare. If there is credible evidence of domestic violence, then there is a prohibition against joint managing conservatorship. This includes child neglect, physical abuse, and sexual abuse. There is also a prohibition against possessory conservatorship if there is a showing of family violence by a preponderance of the evidence. For a non-parent that is seeking sole managing conservatorship, then they must overcome the parental presumption. They can do this through voluntary relinquishment, where the parent voluntarily relinquished for 1 year or more, and the appointment is in the best interest of the child. You could also overcome the parental presumption if there has been significant impairment to the child's physical health or emotional development, or if there is a history of domestic violence. If the non-parent is granted sole managing conservatorship, then the parent must be appointed possessory conservator unless the appointment of the parent would not be in the child's best interest, and allowing possession and access would endanger the child's physical and emotional welfare. If you are not able to overcome the possessory conservatorship appointment, the possession and access section would include a standard possession order with alternating weekends and every Thursday, along with an outline for holidays. Unless you can show the judge, there should be a deviation. If there is drug or alcohol abuse, family violence, or a risk of child abduction, then there is grounds for a deviation. But you can also bring up any other factor that would call for a deviation, such as the parent living in a different country. The sole managing conservator can also request a nonspecific order where it will be determined at a later time. The Family Code also contains provisions that allow the court to determine the risk of international abduction in certain cases and to order preventative measures based on that risk. This can be used to deviate from the presumption that a parent should have visitation rights, but also could be helpful in making a best interest determination. I encourage you to look closely at this section. Finally, child and medical support. If you have personal jurisdiction, then you can ask for child support. Here, we will just talk about current child support and not retroactive child support. The first step in calculating child support is to determine income. If you have no evidence of a person's income or resources, the court must presume that the person's income equals the federal minimum wage for a 40-hour work week. Second, you apply the child support guidelines, which is a formula that involves the percentage of income amount by the amount of children. I'm simplifying it here because I think you can make an argument that the judge should consider other factors, especially if the responsible party lives in another country. The court can deviate from the guidelines for a number of different factors. Medical support is a little different in that it must be included in a SAPSR, regardless of whether there is personal jurisdiction over all of the parties. If there is no personal jurisdiction over one or both of the parents, you can still identify the parent or non-parent conservator as the person who will be responsible for medical support and include that in your judgment. Before you go to trial, you should review the Texas Rules of Evidence. I put on here 3 rules that you should definitely be aware of. The first is judicial notice. The court can take judicial notice of the fact that a pleading has been filed in a case, not the truth of allegations in the record. Before you start with direct examination, it is usually helpful to the judge if you identify your exhibits so that they know what's in the file. I like to have an exhibit list, such as this one. So I can point to it as I ask the judge to take judicial notice of my exhibits. To admit the evidence you want to present, you have to lay the foundation by convincing the judge that what you're offering is what you say it is. If you're presenting a witness's affidavit, allow the witness to identify it as you do direct examination. If you are presenting a birth certificate or other government documents, then it will usually be self-authenticating. Testifying witnesses need to have personal knowledge, and they generally cannot use hearsay unless it meets one of the exceptions. For example, the witness would not be able to say something like, "My uncle told me that my father never wants to see me again," because that would be considered hearsay. Remember that the standard of proof in a conservatorship suit is clear and convincing evidence. This is an intermediate standard that falls between the preponderance of the evidence standard for ordinary civil trials and reasonable doubt for criminal trials. If you have a waiver on file, the case is considered uncontested. Some courts have uncontested dockets where you can go in at any time and prove up or present the case either to the associate or presiding judge. A record can be waived for uncontested cases, but it might be best to have a record, either because USCIS could ask for the record or because you may need it to appeal the court's ruling. If you provided service, the appropriate time has passed, and there has been no answer, then the judgment is considered a default judgment. You must file a certificate of last known address so that the clerk can mail the final judgment to the respondent. The court will require a record in this case under Section 105.003 of the Family Code. Finally, post-trial. Hopefully, you've been granted the relief requested. There's not been a lot of appellate work done so far in SIJS cases in Texas. There may be more in the future, especially as the amount of custody petitions with SIJS findings increase. There's more information on this topic and what you can do even before appealing, such as request a de novo trial or motion to reconsider in the modification of foreign orders presentation. Please let us know if you'd like us to send you that presentation if you were not able to attend the April 1st CLE. If relief is denied and you've exhausted all other options, the first and most important step is to ask the judge for findings of fact and conclusions of law within 20 days of judgment, so that the appellate court knows how the trial court resolved the issue. Remember, in order for the judgment to be appealable, all of the issues and parties must be disposed of. And good news, there are more rules you have to look at, the Texas Rules of Appellate Procedure. In order to perfect the appeal, you must also file a notice of appeal within 30 days. The standard of review for conservatorship orders is abuse of discretion. All right, we'll take a few questions now. Here's one. If a child that is subject of the suit was born due to rape, or in other words, to an unknown man, how do you go about service? In this case, you would need to do citation by publication to an unknown father, and that is under the Family Code at Section 102.010. Another question. If there is an IOTA certificate and affidavit of indigency on file, and there's an appointment of an attorney ad litem or amicus attorney, who is required to pay? In that situation, there is an attorney general opinion that states that the county is not allowed to pay. So the person, the party, the petitioner or plaintiff would be the one required to pay. The judge is supposed to weigh or to balance the child's best interest with the party's ability to pay. So they can take that into account. But if the judge decides that that attorney ad litem or amicus attorney or guardian ad litem should be appointed for the best interest of the child, or sorry, that's only for amicus or guardian ad litem, not for attorney ad litem, then that party will be required to pay. All right, here's another one. How can you satisfy the service requirement if the father is not listed on the birth certificate and is deceased? In that case, you would treat it similarly to an unknown father. You would have to do citation by publication to an unknown party since there's no adjudication of paternity. But you can also look at the termination provisions under Family Code 161.002 for termination of an alleged father if you wanted to go in that direction. Otherwise, you would probably have to do citation by publication for an unknown father and then ask the judge for a finding as to that party, even though he's not adjudicated the father. Another question is, does the court have jurisdiction to establish paternity after serving by publication? And the answer to that is no, generally, because in order to establish paternity, you have to have personal jurisdiction, and you probably would not satisfy one of the 9 long-arm jurisdictional provisions under 102 in the Family Code. So it'd be the same as these other cases where you're just asking for a factual finding without a formal adjudication of paternity. Here's another question about service by publication. If service by publication has been authorized, but the parent is later located, is the service by publication still valid? So I'm assuming that an attorney ad litem was appointed, did a diligent search, and found the parent. In that case, then you would have to serve the party according to the service requirements under the Texas Rules of Civil Procedure since the party is found. Citation by publication is not is disliked by judges in the first place. So if you find the party, then you're going to have to serve in the regular manner. All right, I think that's it. This next slide here has the sources and other resources that were helpful in creating this presentation. For the most part, I used a lot of the O'Connor's resources, the Texas Family Law Handbook, the Family Code Plus, which is great because it has a lot of case law underneath each section of the Family Code, which is especially helpful if you're looking at the termination provisions under abandonment. There's a lot of case law under that section. And also the Texas rules is helpful. I really like the Texas Law Help website. It's supposed to be a pro se resource, but I find it very helpful because it outlines a lot of the issues very clearly. Thank you again for joining us today. I hope you found the presentation to be helpful. Please call or email us with any questions. Our next training will be in about 2 months. It will be a day-long CLE at South Texas College of Law on June 24th. We will be sending out information about the topics and the speakers very soon. In the meantime, we will still be having working group calls. The next asylum working group call is May 11th, and the next SIJS working group call is June 1st. Thank you and have a great weekend, everyone.